All right, let's go ahead and set forth our appearances. We'll start first with the plaintiff, then we'll go to the defense.
Your Honor, Will Kemp for plaintiffs.
Good morning, Your Honor. Teddy Parker on behalf of the plaintiffs.
Robert Egan on behalf of plaintiffs, Your Honor.
Brianna Switzler for plaintiffs.
Eric Peppermint for plaintiffs.
Brad Johnson, Tyler Watson, Michael Esposito, and Eric Freeman on behalf of the defense.
Morning, Your Honor.
Good morning. Okay, we have one matter outside the presence, is that correct?
Your Honor, we do, but it's not going to be an issue for the open, so
We
were
can do it
wondering-
later.
Yeah, especially if we could hold the jury till 12:30, I think we could do our opening statement.
Yeah,
Right.
you'll be fine, you get it done by 12:30?
Yeah, let's do it, Your Honor.
We'll go ahead and do it.
Let's do it. Thank you.
I was thinking that anyway, when I walked on the bench.
Will,
Okay, ladies and gentlemen of the jury, I just want to say good morning to you. And do the parties stipulate to the presence of the jury?
We do, Your Honor.
We do, Your Honor.
All right, and so ladies and gentlemen, it's my understanding we left off with Mr. Johnson, and you're going to give your opening statement, is that correct, sir?
We're ready, Your Honor.
And you anticipate, what, approximately an hour?
I'm gonna try to get through as fast as possible, probably an hour, I'm sorry.
All right, yeah, and the reason why I just want to give the jury some idea, and so we're going to permit him to start his opening statement, and we're hoping to be done around 12:30 or so, and then we'll break for lunch. How's that, sir?
That'll work, Your Honor.
Okay, you have the floor.
Thank you. Well, good morning, early afternoon, everybody. I'll reintroduce myself. My name is Brad Johnson, I represent the defendant in this action. Here's our theme, everybody. I've been waiting so long to hear it. Injustice anywhere is a threat to justice everywhere. It's a well-known statement, and what it means is that whereas there's been 3 opening arguments and a lot of things being said, and a lot of things for y'all to try to remember, and you got like a little notepad, some of y'all have been doing your best to keep up with it, is you got to remember is that I represent a client as well, and my client deserves to have justice as well, and that's why we're here today. Helping me today is Robin Concepcion back over there. Thank you, sir. Also want to thank the professional courtesy of counsel leaving this up here so y'all can, this is not our screen, this is the screen that they brought in, and I thank you for that, sir. Ladies and gentlemen, Real Water is entitled to a fair review of the evidence. A fair review of all of the evidence to prevent an unjust outcome. So although we come second, and there's attorneys ahead of us, we have to wait till all of the evidence is reviewed so that my client also has a fair outcome. Here is what we believe the evidence will show. An opening statement is not an opening argument. I'm not here to argue the case, ladies and gentlemen. I'm here to try to give you a roadmap on where we think the evidence will lead us and what I believe the evidence will show. The evidence will reveal that the plaintiff's retained experts' opinions do not add up. As you are acutely aware at this stage in the case, liability, fault, has already been assessed by the court. My client has been found at fault in this case. We spent a whole lot of time in opening, and I'm not criticizing it, talking about an issue, fault, that's already been decided by the court. Correct? A lot of time. Pointing fingers on an issue that you don't have to determine. Also, in this particular case, it's already been judged that certain injuries in this case are my client's fault, called causation. So when you heard liability, causation, it's basically fault and damages. But you guys have to figure out what the damages are, to the extent those damages exist. That's what this case is about. It isn't about fault, point, etc. Y'all were told that you needed to find out what the damages were. I don't think you heard too much about what the damages were yesterday through 3 openings. Their damages, in large part, are going to have to be determined through their testimony, the plaintiff's testimony. And I want to make it very clear, the plaintiffs in this case are not at fault. They didn't do anything wrong. They got sick, they had to go to a hospital, and they had to receive treatment. but they have to come up with damages for that. And what's going to happen in this case is they went out and they got experts, not necessarily treating experts, not treating doctors, but experts. Experts who are not treaters. Experts that didn't treat them in the hospital. Experts that didn't give them any psychological counseling. Those types of experts are retained experts, and they have to rely upon these retained experts to establish the damages for which you to base your award. To make sense? That's what this case is about. Those opinions don't add up. This trial is not complicated. As I said, much of it's hard to determine. But what we said in voir dire, that's important because there's 13 plaintiffs. If there's going to be complications, it's trying to keep everybody straight. So we're going to do our best to help you do that. We're going to make very clear what we believe to be the damages are on each and every single plaintiff in this case. So you can follow along. So that at the end of the trial, you don't go, what are we doing here? Are we just throwing numbers up? Big numbers? What are they basing their damages on? We don't think that's going to be complicated, but we'll do our best to help clarify those claims so you can do your job. Every story has a beginning, doesn't it? Our case is no different. Our story began in 2008, Real Water. Brent Jones, his wife Amy Jones, subsequently their son, operated Real Water. 10 years successfully when all this came down. They sold alkaline water. Ladies and gentlemen, they had the bravery to start their own business, to put themselves out
When
there.
we approach,
They had,
and we approach.
Yeah, we can. All right, ladies and gentlemen, we just had a brief discussion sidebar. We have one objection, and I sustain the objection. The size of Real Water or how long they have been in business and those types of things have no relevance. I've already ruled on that issue as a trial court. Just as important to raising issues regarding bravery and starting a business. That has nothing to do with what's presented in front of you also. Just wanted to let you know that. And so what we're going to do is we're going to continue on with opening, sir.
thank you, Your Honor. Brent Jones is the owner of the company. He lives out of state. And like many witnesses in this case, we anticipate that he'll be testifying by deposition, sworn up. Next, we're going to talk about the outbreak.
Your Honor, we approach.
Continue on, counsel. Thank you, everybody.
Objection sustained, Your Honor.
Yes.
And as you've heard, in late October of 2020, the evidence will show that Real Water learned of an outbreak of liver ailments related to Real Water. As the plaintiffs said several times in their openings, the doctors could not figure out what the cause was. Once they did, notices were provided by doctors, health officials, and ultimately attorneys about the outbreak, and soon a relatively small group of people began coming out of the woodworks, claiming they too had gotten sick and wanted compensation. Plaintiffs stated in their opening about dozens of complaints, and they flashed something up there. Those were over a decade period of time, and if recollection serves, complaints didn't always deal with anything dealing with liver ailments. In fact, there was years gaps in complaints for over a decade. They also made representations in their opening that there was no testing. I don't know how many times they said there was no testing. They never tested, etc. In your book, Exhibit 5 would suggest those representations in the opening were not accurate. Exhibit 5 is a wet lab test that was run by my client, and the results came in January. If you flip to the back of that exhibit, you'll see that Blaine Jones sent that out on November 14 of 2020. After the outbreak in October and November of the same year. They sent water out to be tested. There it is. Do they know to test for hydrazine? No. They know to send it out for testing, find out what's going on, because the evidence will show the hydrazine link was not found until the FDA issued a report much, much later in 2021. And if you look at that particular exhibit, you know, the exhibit that shows testing was going on and they said that there wasn't, went through a number of tests, trace metals tests, etc. And on page 3 of that test, the only thing, quote unquote, that didn't pass was the pH of the water sample. It came in at 8.85, it's the third line down, if you'll see this. It was supposed to be within 6.5 to 8.5. There was testing. There was testing going on all of the time. That representation to you was inaccurate. And that's unfortunate, because you had to think about that overnight after it had been repeated numerous times. That won't be the evidence that was presented. And you know that already on day 1, Exhibit 5. I can move on. Ladies and gentlemen, plaintiffs have the burden of proof on each and every element of their claim. And the minute the claim was filed, up until the time the court issues rulings, up until time that you have to make determinations as to damages. We don't. My client has an absolute right to challenge every step of the way and to have the plaintiff establish what their claims are. They have the burden of proof. So let's talk about their burden of proof on their claims. Ladies and gentlemen, this is the important part. This is the part that I would like you to maybe figuratively, mentally lean forward in your seats, because this is where the rubber hits the road on the case. What are their claims? What are their damages? Well, it's great news, basically. For the most part, on all of these plaintiffs, save a few, will establish, we just may have to go verbal. Go ahead. The symptoms subside. Go ahead. There's no follow-up needed by these plaintiffs. Go ahead. No monitoring needed after they've been released. Yes. No psychological treatment received. No current treatment, for the most part, for these groups of plaintiffs. Go ahead. No medications anymore. And no limitations. That's great news. Objective, great news. You wouldn't have known that from the openings you heard yesterday, but that's what the facts will show. That's what the evidence will show. Nobody's dead in this case. Nobody had a liver transplant in this case. No one's on a liver transplant waiting list, but the jet on standby. In this case, you may not have known that based upon the openings. I'm telling you, now, the news is great. Now, as I stated, the folks who are plaintiffs in this case are nice people, they're not to blame, but they did go to the hospital, they did get treated, and they did get better. The absolute great news is that their symptoms, with a few exceptions, resolved, and they have no ongoing treatment or complaints. Because this is a particular instance where their livers were impacted. We anticipate introducing evidence through the plaintiff's own expert that the liver is a wondrous organ. Not only is it the largest organ, not only does it do, I've heard somewhere between 250 and 450 different functions for the body, but it is the only organ that regenerates. It repairs itself. And that's what's happened in this particular case with these plaintiffs' claims. Unfortunately, some of the claimants have issues such as MG that have been lumped in with all the other folks whose claims relate primarily, if not exclusively, to their livers. They're all here together. We don't have control over that. That's just how it's going to be presented to you. So I think it would be a real good place to start at this point is, go ahead please, talk about the plaintiffs. What are their damages? The court has already issued a ruling on compensatory damages related to medical care these individuals received. And I'm going to go through that. And what I use, y'all don't have to do it. You see that little picture book thing there on the front? I just wrote down above their names what those damages were in terms of their medical treatment damages. It's a little way to keep track of it. Y'all don't have to. But here is what the court has ruled as it relates to the reasonable and necessary and customary care related to the medical expenses in this case. It's hot off the presses. It's February 26, 2025 order. Would you bring it up, please? Almost in order. Andra Bordenage, $387,000. Nicole Chang, $132,000. This relates to the medical care. It's hard to see. It's related to the medical care. Hey, do you know how to do that deal where you blow it up a little bit? Those numbers? Is that better? All right. Nigel Davis Richards, $121,000. I just stuck it right over there, the heads, right? Then look what happens. James Delmar, $56,000. Lisa King. This young lady is the one who had the MG. $696,000 going to doctors. Ginger Land Van Buren, $130,000. Carrie Mano, $84,000. Glenn Morris, $59,000. Cheryl Nally, $62,000. Abraham Oliveira, $163,000. Those are the medical specials they incurred for the treatment the court's ruled upon. See, there's a big range in there. Big ranges here. See any billion-dollar numbers in there? Well, that's what medical specials are, but that doesn't necessarily equate to what their damages are, right? You could have someone die in an accident and have a AMR med record for $1,000 saying they passed away.
This is argument. This is
I'll
all
sustain.
argument, Your Honor. Thank you.
I'll sustain.
We have to get into what their actual damages are. Go ahead. Ginger Land Van Buren. Here's what we believe the evidence will show for her. She had a follow-up visit with her doctor after she was released from the hospital in January 2021. Unremarkable. Laboratory results had returned to normal. Next. At least the time of her deposition, her last treatment was 2.5 years ago, ladies and gentlemen. Not currently treating for their injuries. Is able to do all things she could do prior to her injuries. Those things will get right out of her mouth. That's her tragic story. Next, please. Vanya Diaz, another plaintiff in this case. Follow-up visit with her doctor in January of 2021. Look at the good news, ladies and gentlemen. We'll show that she had significant improvement in her liver lab studies, and by March of 2021, they were even lower. Fantastic news.
Argument of objection, Your Honor.
I'll sustain.
Next, please. Vanya Diaz. She'll testify she hasn't treated with her gastroenterologist since 2022. No follow-up appointments currently scheduled, at least when her sworn deposition was taken. No future care or treatment plans with a hepatologist, that's a liver doctor. She's able to do the same activities as she did prior to her injuries. We believe that's important for you to know when assessing damages. We go to the next plaintiff, please. Nicole Chang. Ms. Chang's the person you saw, I believe, maybe, well, I won't even hazard a guess. Bottom line is, we'll establish the facts that she was admitted to the hospital in November of 2020, and when she was discharged 6 days later, she had improved. By November of 2020, she was asymptomatic. No more symptoms. Go ahead. We'll establish through her testimony, she's no longer testing, no symptoms since her hospitalization, and no future care from her treating providers. You're getting a feel for what the facts are going to be in this case. Next, please. Mr. Davis Richards. He too discharged from the hospital on December 2nd, 2020, after improvement over several days. He's in the hospital, he gets treatment, he improves, he does a follow-up, makes sense. All symptoms had improved. Ladies and gentlemen, we're not going to skip over anybody. Mr. Davis Richards, we'll have him testify at the time of his deposition, no longer experiencing any symptoms related to his liver. Last treatment was 4 years ago. No treating provider recommended future treatment. No relapse or flare-up since last treatment. No longer on any medications. No limitations in his day-to-day life. Let's keep going. James Delmar. One we heard some musical accompaniment the other day. He was admitted to the hospital on June 14, 2018. He was discharged on July 6th. His symptoms had resolved. Go to the next. He admitted in his deposition he's feeling better the next day. Move to Kerry Mano. See Mr. Mano here regularly in the gallery. He was discharged on December 23, 2020 with improved conditions. That was 4 years ago. His deposition was taken. His non-viral hepatitis had resolved by his own admission. Current labs are normal. Symptoms resolved within 2 months. One-time follow-up visit was in February of 2021. No relapse or flare-up since last treatment. No plans for future treatment. No longer on any medications. No treating provider advised that he would have any long-term problems. He's able to do all of the things he could do prior to his injuries, and no change in his pre-illness recreational activities. That's a plaintiff in this case. Glenn Morris. Didn't hear much about him. Well, Mr. Morris underwent testing at UMC for causes of liver injury, went under all of the tests, viral, infectious, autoimmune, metabolic. All tests were negative. He was discharged with no further care. Took his deposition. We believe he will testify. He has an upset stomach on occasion, takes a pill to make it go away. No psychological or emotional injury. Only went in his house to get sick from drinking real water. We'll go on. Cheryl Nally. Ms. Nally's symptoms subsided after being discharged. She required no routine monitoring. She required no follow-up visits with any of her healthcare providers. Took her deposition in June of 2021. She was told by her treating physicians that her liver was, quote, not having problems, close quote. No routine monitoring of her liver. As of November 26, 2024, no follow-up visits scheduled with their healthcare providers regarding real water. These are the individuals who are bringing claims today, seeking damages, and how they're doing. We'll move to the next one. Young man, Abraham Olvera. Go ahead. He was present at the hospital November 6, 2020, discharged 3 days later with a liver injury test rapidly improving. Ladies and gentlemen, he had one follow-up visit. Deposition was taken. We anticipate if he testifies consistently with that testimony, most recent clinic note of December 2020 reports that his liver enzymes are normal. He's made a full recovery. No apparent long-time complications. There's another plaintiff in this case. You got a little picture on that. Go ahead. Kathleen Garcias. Next. Plaintiff's experts ignored her completely. You won't hear from Dr. Hudson or Dr. Sands as it relates to Ms. Garcias. She's claiming indigestion. Not sure why she's in her case. This was the individual that it was suggested to you in opening her case was worth $1 million. Next, please. Carolyn Strong. Again, her liver enzymes are back to normal. She continues to get checked every 6 months. Carolyn Strong. Excellent long-term outlook supported by, that's right, complete normalization of liver function tests, absence of significant fibrosis on biopsy, resolution of all clinical symptoms, no evidence of chronic liver injury. Keep rolling. Miss Bordenave. Very nice lady. Miss Bordenave had to go through 3 hospitals to find out to get any improvement. She was a couple hospitals here, and had to go to USC. Very nice lady. But her last drink of real water was in February 2018, and by March of 2018, her condition had improved and she was discharged. Go ahead. As of her deposition of October 24, she was working full-time, Monday through Friday, 7:30 to 4 p.m. with no difficulty. She has anxiety, but it's not related to real water. She's on medication. It's not related to real water. As far as she knows, she has no ongoing issues with her liver. No future medical or treatment plans related to injuries in this case. Next, Lisa King. Lisa King's deposition in this case was taken in March of 2024. Now, you're going to have to lean forward in your seat on this one because this is a moving target. Some of you know about MG. According to her experts, she needs to have an unspecific amount of follow-up visits with a hematologist and neurologist. She suffers from the condition MG, but she will admit that, at least at the time of her deposition in March of last year, it's not impacted her ability to work, to perform her duties, or to prevent her from traveling extensively. Go on to the next. Ms. King testifies she drank real water beginning in 2014 with no problems until August of 2019. Testifies she stopped drinking real water in November of 2019. During this period of time, she was able to continue to travel to Puerto Rico, Germany, Shanghai, China, Hawaii. She never saw a psychiatrist or a psychologist of any sort or therapy for anxiety or post-traumatic stress disorder. He has a doctor, Dr. Hudson, who made certain opinions in a report dated November of 2024, short 4 months ago, in which he said that she would need to have the IVIG infusions that y'all heard so much about, would have to have those quarterly. That would mean once every 3 months. Yet, we were able to present evidence in this case that despite that recommendation, she had not received that IVIG infusion for 14 months, completely at odds with what her expert said she was going to need to have. That expert's deposition was taken and he confirmed those opinions. Yet, we believe that this number has changed. We believe that it's no longer going to have injections quarterly, but from the opening, it was stated that she's going to have these infusions twice a month, every month, for the rest of her life. We learned of that when you learned of it yesterday. You'll have to gauge the testimony of the experts in that regard. We'll learn it together. Ladies and gentlemen, as I said, there's going to be moments in this trial where you need to lean forward in your chairs and focus on what's going to be presented to you. We have to look at the plaintiff's experts. Can we pull up the next slide? Like I said, they have collective experts that treated or provided opinions on almost all of them, save Ms. Casillas, the mystery plaintiff in this case. One is Dr. Stephan Sands. You heard about him. The other is Dr. Hudson. You heard about him. I'd like to go through those, what we believe these experts will say. Go ahead. Stephan Sands. He is a retained neuropsychological expert from New York, not a treating doctor. He has opinions on 12 of the 13 plaintiffs, not Ms. Casillas. Ladies and gentlemen, we'll establish one size fits all with him. He provides opinions regarding future care. They're all the same. So we'll establish it doesn't matter how old the plaintiff is, the result of the testing, whether they had evidence of invalidity in their testing, the extent of their medical care, the test that he provided, the number of tests he provided, whether those tests were done live or remotely, the timing of the exposure, whether they claimed psychological injury or not, or the actual injury claim. No, he would give a cookie cutter saying everyone needs the same amount of psychological treatment whether they've received it or not, or whether they even claim they need it. Be ready for the cookie cutter. He's coming. Didn't touch on him too much in the opening, I noted. Moving on to the next. Universal expert, William Hudson. You'll hear from him. He's another non-treating expert. He does not have a doctor-patient relationship with any plaintiffs. And I'll tell you, in this particular case, he didn't talk to any of them. He reviewed medical records and came up on opinions on what's related, etc. He testified last month will establish that none of the plaintiffs in this case have a definitive evidence of scarring on their livers. He will testify that if a person suffers from a hydrazine-induced liver injury, they have a 100% chance of relapse once they stop taking the hydrazine. That's 0%. I must have misread that. A 0% chance of relapse on a liver injury once you stop taking, that's right, a toxic hydrazine. Once you do that, you have a liver injury, you have 100% of no relapse. Additionally, if they have acute liver failure, which is not to be confused with a liver injury, a liver failure, 90% of the people have a full recovery. 90%. When you talk about greater than not, 51% butterfly on the scale, it's 90% of people have a full recovery. These exposures were over 4 years ago, ladies and gentlemen. And incredibly, we got him to admit that he has a personal reason to want to be in this case. Dr. Hudson wants to get notoriety out of this case and his opinions. That's the type of expert they have. It's about him.
Well, that's argumentative, move to strike.
I'll sustain on that small issue. Go ahead.
Thank you, Your Honor. Defense experts. Go ahead. Call Dr. Howard Robin. He is a pathologist. He is a consultant to laboratories, clinical research organizations, and pharmaceutical manufacturers. He was trained at Chestnut Hill Hospital, Thomas Jefferson Hospital, and Scripps Clinic and Research Foundation. And he has clinical and pathological expertise in kidney and liver disease. He'll testify on behalf of the defendants. Moving on, defense expert Angel Alsina. He's been a liver surgeon for 24 years, trained at Harvard University. Go on. Broad knowledge of general surgery, liver surgery, transplantation, hepatology, and directed liver transplantation and liver cancer programs for 20 years. He'll testify about ongoing issues with these particular plaintiffs. Additionally, we have defense expert Henry Lynn. He is a pediatric gastroenterologist, pediatric transplant hepatologist, trained at these hospitals, currently professor of pediatrics and head of division of pediatric gastroenterology at Oregon University. His background is in pediatric liver disease, including clinical research. He too will be providing opinions. Go ahead. Ladies and gentlemen, our case relies on your intelligence to reach a fair and just result. Our defense is going to be based upon facts and rational understanding of those facts and your general intelligence. We're not going to appeal to your emotions. If you hear arguments in this case, and things are arguments directed towards your fear, you need to be aware of it. We'd ask that you not be misdirected and be on the lookout for trigger words. Ladies and gentlemen, when the facts are presented in this case, there are no plaintiffs in this case that are puppies. No plaintiffs in this case who are babies. There's no defendants who are Nazis or Russians or silly, unknown, mystical creatures fighting the rock. No one drank water that doubles as rocket fuel. I doubt very seriously these types of comparisons will be continued to be made
I object to that last comment about rocket fuel. The court has found as a matter of
Your Honor.
law, excuse me, as a matter of law, that there was hydrazine in the water, which is rocket fuel.
I don't.
I'll sustain in that
Thank you, Your
regard.
Honor.
We'll wait to see if those arguments are made. And if they do, you can recognize why they're being made and filter that.
Your Honor, again,
If-
this is a violation of Rule 3.4, Your Honor.
I'll sustain.
Thank you.
No
One after
argument.
another.
The irony of the plaintiff's cases is this, is they have packaged up their claims, like the water.
This is argumentative. Your
I'll
Honor.
sustain.
I mean, is
No
this going to go
argument.
on forever? Every statement is a violation of the rules?
Move the
Can we-
strike
can
and
we approach-
objection, Your Honor.
Can we approach?
The objections is
Yeah,
sustained, Your
for the
Honor.
record, I'm going to sustain the objection. Mr. Johnson, continue on, sir.
The objection was argumentative, Your Honor.
Argumentative, and there is an issue regarding justice of the cost.
Thank you, Your Honor. Ladies and gentlemen, we're back to your intelligence and a fair and just result. All the facts are presented to you as it relates to damages. Talking about their experts, if they're going to come in, and their testimony as it relates to what they spent 3 days telling you. They were going to be able to prove in terms of those damages, the $1 million, the $1 billion. It won't add up. Thank you. Thank you, sir.
Thank you. Thank you, Matt. Okay, ladies and gentlemen, I think we should break for lunch, don't you? And remember, you're admonished not to converse amongst yourselves with anyone else on any subject connected to this trial, or to read, watch, or listen to any report or commentary about the trial by persons connected to this case, or by any medium of information, including without limitations, newspaper, television, radio. Remember the social media prohibition. And last but not least, do not form or express any opinion on any subject connected with this trial until the cause is finally submitted to you. And it's 12:30, 1:40.
140, Your Honor. All rise for the departure of the jury.
Is this being real-time recorded?
We're getting, I think we're getting creative. I don't know if
Yeah, Judge, there was some discussion that the board people wanted it to be real time. So there was a discussion to talk to Barnabas judges to see if it was going to be a live broadcast. And I know they were making an effort to do that, but I don't think they're there yet. So it's.
Well, the only reason I asked that question, it would have been a little help. You know, when I was the last holdout until my court reporter retired on me, and I couldn't really find someone to replace her. And that was one of the true benefits I really appreciated from her, was the fact that we always had real-time reporting in this department.
Well, I think we have live transfer.
And the only reason I suggested that, it would have been nice if we had something available, because I know we're gonna have a discussion after lunch as to exactly what I should do. And, all right. So we'll deal with this, what do you think, come back at about 12:30? 1:30, I mean.
12:30 now.
1:30.
12:30 now.
1:30.
It's fine.
1:30.
All right.
Barbara, Stephan, I'll come back to order.
We are on the record, Your Honor.
Yeah, thank you, ma'am. Let's go ahead and set forth our appearances.
Your Honor, we'll come for plaintiffs.
Good afternoon, Your Honor. Teddy Parker, we have the plaintiffs.
Robert Eglin on behalf of plaintiff, Your Honor.
Whistler on behalf of plaintiffs.
Eric Peppermint, complainant.
Brad Johnson, Tyler Watson, Michael Esposito, and Eric Freeman on behalf of the defendant, Your Honor.
All right, let's go ahead and continue our discussion. We had,
Yes, thank you, Your Honor. Yes, Your Honor, I've been, let me start out. Okay, go ahead. Plaintiff, Your Honor, I just want to recap what has occurred in this so-called opening statement of Mr. Johnson. He first started, well, fact, this is not really relevant, but he did misquote Martin Luther King in his quote terribly. But at any rate, he starts out by saying the plaintiff's experts do not add up, which is argument. He goes then to a direct violation after he says causation is already decided. He then goes to a direct violation of that, which he did when he did one of his introductions to the jury, and he did it several times during voir dire, when he said what the damages are. You will decide what the damages are to the extent they exist. And this court has already found as a matter of law that each and every one of these plaintiffs have been damaged, and that their damages are the injuries that they have been diagnosed with and claim. He went on to say again that the plaintiffs went out and got experts, not necessarily treating experts, and these opinions don't add up. Doesn't state what their opinions are, he just says they don't add up, and that is again argument. And then he proceeded to violate this court's pretrial order that defense counsel was not to suggest, insinuate, or attempt in any way to plant the suggestion in the jury's mind that this was a small family-owned business or small business of any kind, when he began to tell them that, well, Brent Jones started this company and with his wife and his son, and they had the courage to start this company. Clearly, there can be no other reason to do that other than, in fact, to plant the suggestion in these jurors that this is some sort of very small, family-owned company. He then went on to talk about the individual plaintiff's claims and said things like, this is great news, this is fantastic news. Again, argument, Your Honor, improper, totally out of line with our rules and this court's pretrial orders. He then went on to suggest that the plaintiffs were claiming that there were babies, some of the plaintiffs were babies in this case, or that one of the plaintiffs died in this case, or that any of the plaintiffs in this case had liver transplants. None of that was suggested in any way, shape, or form to the jury. And I'm not sure Mr. Johnson understands product liability cases and that the plaintiffs are permitted, and this is evidence of other people being hurt by the same defective product, even if they are not plaintiffs in the case that is occurring. It is appropriate, it is done in every product liability case. This is mine and Mr. Kemp's 8th or 9 together, and it was allowed in every one of them because that is the law. Then when he suggested that all the plaintiffs were lumped into this case together as if that was some sort of improper thing to try all these plaintiffs' cases together, again, an attempt at disparaging or suggesting that plaintiff's counsel was doing something unprofessional. He also misrepresented the amount of Lisa's past medical specials, which they are fully aware of, are not $696,000 and change. They're over at $900,000 at this point. They've been aware and have had the record from her last IBI treatment, which was over $200,000 before the court. So it became absolutely unbelievable how many times we had to object during his opening statement, because it is quite clear, Your Honor, it's certainly quite clear. Oh, by the way, he also, the way he suggested that, oh, this is the first time we've heard about this, that she's going to need monthly IVIGs. Well, that's not true, but at any rate, because it's in the medical records that Dr. Mahajan had
had put this as a recommendation years ago. And then it got to the point he was concerned that she was gonna die, and he absolutely insisted on it. So that is not true, that they didn't know that that was a possibility, but the way he framed that suggestion and the way he suggested to the jury is that her lawyer, me, had something to do with orchestrating her medical treatment, which is an outrageous lie. As soon as I learned that this is going to happen, I immediately notified the court and counsel, and you have an affidavit from me to that effect that was filed with our trial brief on this issue. So, Your Honor, I don't really quite know what to do. I know that Mr. Kemp has come up with a limited instruction. I think counsel has to be admonished to this jury for his unprofessional conduct. And I will tell you that there is nothing I can read out of this more. You know, and as court knows, I've been doing this a long time. I've tried a lot of cases, and there's nothing I can read. There's no explanation for this, because Mr. Johnson is a very experienced trial lawyer. He's been trying cases in our jurisdiction for 30 years. So the only thing that you can conclude that he is trying to do here is to force a mistrial in this case. That is what's occurring here. He is attempting to force a mistrial in this case. With that, I'll sit down and I'll let Mr. Parker, or you got some things to say, Betty, or not?
I'll be brief, Your Honor.
And then Mr. Yeah.
I'm not going to repeat the things that Mr. Eglett just articulated, Your Honor. I just want to have the court think back to 3 prior occasions where this similar conduct has been brought before the bench. We've had discussions about it. The court has admonished Mr. Johnson not to do it again, and he continues to do it. And it's becoming an exercise that I think the jury is seeing play out way too many times. I think it's disruptive to this trial and getting this case tried. But I will remind the court, this is day 2 of the trial, February 25th. This is page 60 of the transcript. And Mr. Johnson says to, I believe, juror number 80, right after we had this conversation, he says, "Thank you, Your Honor." And he says, "Now nothing has been proven in this case. You understand that?" That's his words out of the transcript, page 60, lines 8 and 9. I mean, that's direct jury nullification after the court has instructed this jury of the things that had been proven and decided by the court. The following day, Your Honor, February 26, 2025, page 31. And, Your Honor, you took exception to his comments, and ultimately it was brought before the court. And he says, "Good morning, everybody. My name is Brad Johnson. I represent the defendants in this case. This is really a case about the plaintiffs are claiming that they are injured, the extent of their injuries. And we're going to be asking you guys to individually look at these individuals' claims and determine if, in fact, they were proven claims. Because it's their burden. That's what it's about, determining what these people claim their injuries are and what you truly believe how they were injured." In between the lines and in the lines, again, he's questioning whether or not they have been injured. Your Honor, again, jury nullification at its best. At its worst, just a clear and blatant disregard of the court's pre-trial decisions in this case. And then finally, Your Honor, on February 28, 2025, this is page 40 and 41. This is where he tries to endear himself to the jury by saying, and I'll read it, "I'm at a disadvantage already. Can everyone raise their hand and agree with me that I'm at a disadvantage already? Can you raise it up high so I can see it?" Talking about and disparaging the process by which our state has decided jurors are supposed to be selected. Your Honor, he has repeatedly, despite all of our attempts to confine him to the rules, to blatantly disregard the rules. Mr. Eglett's comments are in addition to these. I want the court to consider it as you decide what's the appropriate action to take today.
I got one question for you, Mr. Parker. You did raise sidebar, justness of the cause.
That's exactly right, Your Honor. And that comes from Nevada Rule Professional Responsibility 3.4, which I showed Mr. Johnson from my phone. I repeated it to the court. I typically have it with me when we're going through voir dire just to remind counsel to bring it up. I didn't bring it today, but that's exactly right, Your Honor. No lawyer is allowed to put before the jury his opinion of the case, or the justness of the cause, his impression of a witness, which he also did. And so, Your Honor, those types of conduct are specifically prohibited by our rules of professional conduct.
Your Honor, I'm not going to argue. I'm just going to read in a proposed curative and then hand it to the clerk. Quote, ladies and gentlemen, the purpose of opening statement is to discuss the evidence that will be presented. This is not the time for the lawyers to argue. An argument at this time is prohibited. Mr. Johnson violated our rules by arguing that plaintiffs were doing, quote, great, had, quote, great news, unquote, and made a, quote, fantastic, unquote, recovery. You are instructed to disregard these arguments. Mr. Johnson also violated our rules by suggesting that real water officers were, quote, brave, period, unquote. This is an opinion which is prohibited. You are instructed to disregard this argument. Mr. Johnson also implied that there were not damages by saying that to the, quote, extent these damages exist, unquote. The court already determined that the plaintiffs were damaged from drinking real water. You are to disregard the argument that damages do not exist, period. That, I think that's pretty mild, Your Honor, if I can approach the court.
Have you showed that to Mr. Johnson yet?
I would suggest that what be added to that is his comment about the justness of the cause.
Am I allowed?
Oh, absolutely.
Am I allowed to respond to that?
I've never permitted someone not to respond, and just as important, make a record. I just wanted you to take a look at it first.
I trust what's on the papers, what counsel said.
Okay, all right.
All right, Your Honor, if I may respond in order. These terrible violations the counsel has brought up. First one is stating that their obligation is to determine what damage to the extent they exist. Your Honor, we've already told the jury that they are the ones who are going to determine what the damages are. And obviously, to the extent they exist, they're going to determine that. Whether or not they determine there's future damages hasn't been determined by the court. To the extent they have compensatory damages has not been decided by the court. The jury's going to make that determination. And to the extent they exist, perfectly okay. Opinions don't add
But here's
up.
my question. There's no evidence. Is there going to be evidence presented that they weren't injured as a result of real water?
There's going to be evidence that they don't have any future needs.
Well, no, you didn't answer my question. Is there going to be any evidence presented to this jury that the plaintiffs in this case did not suffer damage?
I told them that they did. I told them they suffered damages. I went through each item, line by line, to the penny, on what the courts ruled on the damages they sustained. I told them that, Your Honor. I'm the only one who did it. So, no, I didn't suggest to them there's no damages. I am the only party in opening arguments to actually address it, Your Honor. Thank you for bringing that up. We're going to establish that based upon the testimony of the plaintiffs, as I went through in painstaking detail through their depositions, that the experts' opinions regarding damages don't add up. That's not improper. Third, the suggestion that a small family...
That the experts' opinions don't add up, you're not saying that that's not argument? You're not saying that that's a proper way to conduct an opening statement?
What I'm saying is that's the theme of this case, Your Honor. Their experts' opinions don't add up. Their next issue was suggesting the small family-owned business. We talked about this at length and at the bench. The order on this motion in limine, they're saying I'm violated, I've yet to see, but it's disputed language. Like most of the orders that have been presented in this case, they're distinctly different than what was argued. In opening arguments, Mr. Kemp mentioned Brent Jones was the owner of the company. So are they violating the
Maybe
very
we just have a
same?
misunderstanding because you even termed it in opening arguments. That's problematic, but go ahead.
Well, no, that wasn't opening arguments, Your Honor. Mr. Kemp mentioned that Brent Jones was the owner of this company. That's what they said.
You didn't mean opening statements?
I'm sorry, opening statement. I apologize, Your Honor. I know that's a stickler. Opening statement. They brought it up. I can address it. There's no motion limiting that I violated. They also brought up Blaine Jones, his son. I'm pretty sure Sam Walton started up a company himself, Your Honor, and it's $1 billion company. I have to be able to say who our witnesses are and how they fit into this picture. I didn't violate a motion in limine order. I'd like to see it if I did. Next, this is great news. That's argument. That's a fact, Your Honor.
No, say that one again.
That this is great news, that these people were, that there is a zero recurrence rate on drug-induced hepatitis once the drug is removed. That's argument, that's great news. No babies, no one died, liver transplant. All of those images were placed in these jurors' mind that that's what this case was about. Their distinction is, well, you don't understand product defect. Those things can come up. They didn't make that clear to this jury.
Well, I don't think they necessarily had to, because what they were doing was they were discussing the state of the evidence as a result of the investigation and the foundation for like the CDC, the Nevada Southern Health District, and those types of things.
And as I sat here, and any juror who doesn't know anything about this case, it gave the impression that in this group of plaintiffs, there were babies and deaths and liver transplants. I have to make that clear to the jury. I don't know how sophisticated these folks are, Your Honor, but that was what was said repeatedly in opening arguments. That isn't what this case is about. There's 6, all lumped into this case together. Your Honor, they are lumped into this case together. That is one of the largest challenges that everyone has in this case. All of these cases are lumped in together. They have to be reviewed separately and carefully. They're not all the same. You would think that would be a point that would be made by all of us. You can't just lump them together. And that's why I pull them out one by one. The only one who seemed to be concerned about that. Number 7, suggesting for the first time that they need IVIG. I don't know why Mr. Eglett thinks I have it in for him. I do not. The point is this evidence where the future care for Ms. King has tripled was just disclosed today, Your Honor. Today is when it came down. They have to know those are going to be the facts, because when these facts are presented, when they bring in their neurologist, I think who was just served today without an expert report, by the way.
He's a treater.
Say again?
He's a treater.
Okay, these still have to be disclosed.
No, you don't.
Again,
Wait, go ahead, I'm gonna listen to you.
I certainly would like to address the bitch. Is a treating doctor has to be disclosed under NRCP 16.1. That's black letter law, I don't need to tell you.
He was disclosed.
Okay, well, I guess we'll cross that bridge when we get to it. The point is, that came today. Now, that was mentioned to the jury in the opening. We don't even have the report, Your Honor. Mr. Eglett went on and on about that and how terrible this is and that she's going to die. If that is an argument, I don't know what is, but it's prevalent throughout all of these openings. So it came up today, the first time we had to see it. They're going to have to be able to understand we took Her deposition, she hadn't had one in 14 months. That's a fact. We took Hudson's deposition. She says, well, he may not have had an injection 14 months, but I think it has to be quarterly. Today, and I still haven't been able to look at it, is now that's been tripled. I have to be able to tell them how it played out. It is not that Mr. Eglin held anything back. It shows how the doctors have been inconsistent on that issue and inconsistent in terms of the treatment. It goes from 14 months, it goes to once a quarter, and now it's twice a month, or whatever the latest rendition of that is. Next, number 8, discussing violating Rule 3.4 and the opinion of the justice of the cause. I don't know where they got there was a justice of the cause other than a slide at the end that my client is entitled to justice. There's never been an argument as to the justness of the cause that would implicate Rule 3.4E. All of my representations are based upon my understanding of this court's orders. All of the representations I made were based upon what I believe the facts would be presented in this case. All the statements I believe were appropriate in terms of an opening argument. And while the court understands...
I think that's the problem.
That's the problem. It's already a statement, not an argument.
And that's the problem. The opening statement, there have been opening arguments in this case for 3 days. We sat through profits over safety. We sat in over monsters coming out on, we got into she's going to die. All of those, I guess, were opening statements as well as they defined them. But it's been prevalent throughout. So I don't deserve an instructive, curative instruction in this case any more than these learned attorneys do, Your Honor. Thank you.
Thank you.
May I respond, Your Honor?
Yes, you may.
All right, so first of all, Mr. Johnson is rewriting history here. The court has decided that the plaintiffs have been damaged, and Mr. Barker pointed out all the various times throughout this trial that he has stated if to the extent they have been damaged. He has said that over and over and over again, and he said it again in his closing argument. That is a clear violation of this, what's that, opening statement. It's a clear, now he's got me doing it, clear violation of the court's order on this issue on causation. You didn't just find general causation in this case, you found specific causation to each and every one of these plaintiffs' injuries. And so that is just a attempt to rewrite history. The experts' opinions don't add up. Now, he could set forth in his opening statement the various experts' opinion and then ask the question, you'll have to decide whether these add up. But he can't stand there and make the argument that they add up. Just like when I said you will have to determine whether they put their profits over patients' safety. I didn't argue that they did. I said the jury will have to make that decision. And that's the subtle distinction there is between argument and basically giving an open statement stating what the facts are, Your Honor, and telling the jury the questions they're going to have to answer in this case, which apparently Mr. Johnson either refuses to get or maybe he just doesn't get it. He's clearly suggested to this jury that this was a family-owned small business, and we argued this to the court specifically, and we argued that they could not suggest, insinuate, or in any way try to place in the jury's mind that this was a small business or a family-owned business, and the court granted that motion. But your order was signed on the 28th, and Mr. Johnson is saying, now I haven't seen an order on that. Well, it was signed on the 28th. The order is in place, and so There is no excuse for that, and it was a clear, absolute violation of this court order, a clear violation of our professional standards of conduct for lawyers in this jurisdiction. And so, that alone deserves a sanction, monetary sanction, and an admonishment for Mr. Johnson. And at this stage of the case, how this has gone on and on, I would suggest nothing less than a $50,000 monetary sanction. Great news. This is fantastic news. That is argument, Your Honor. He can tell them what the records say, but he doesn't get to do commentary on, oh, this is great news, fantastic news. Again, babies' deaths was not placed in the jury's mind. It was not placed in the jury's mind that any of the plaintiffs, or that any of the plaintiffs were babies in this case, or that there were deaths in this case, but that was brought out by the Southern Nevada Health Department and joint investigation with the CDC and the FDA. That is evidence that is related, that is relevant to this case in a products liability case, and it's clearly relevant for punitive damages. When he made the suggestion and the way he said it, that the plaintiffs lumped all these plaintiffs together, you know, why would they do that? He's clearly stating or suggesting to the jury that the plaintiff's lawyers in this case engaged in some sort of improper misconduct by doing that. The IVIG treatment. Dr. Mahajan, in his records, which they have had for years, in late 2020 or early 2001, suggested monthly IVIG treatments for her, and she actually had about 3 straight months of IVIG treatments. It was very difficult for her, so she stopped doing it monthly, and he allowed her to go ahead and do it on a, as she had a flare-up of her MG symptoms. But again, he's again suggesting by the fact that, oh, we just heard about this today, we just heard about this the other day, in his opening statement, is again suggesting to this jury a clear Leochi violation, that counsel is somehow trying to manipulate Ms. King's medical treatment. You have my affidavit, Your Honor. I think I've tried about 7 or 8 cases in front of you, Your Honor. I think you know my reputation and my credibility, and I'll leave that as it is. But that is clearly what he, and he also said, she went to China. That's an absolute lie. That's just a flat out lie. There's no evidence they have that she went to China. Okay, they have a post of her partner, Brett, made a post from China, and that side said Shanghai. She wasn't there, and she told them that in her deposition. Sanctions are warranted. At a minimum, this limiting instruction is warranted, Your Honor.
Mr. Parker, anything you want to add in this?
I think the court understands exactly what's happened. It's happening in front of you. We're prepared to rest on the court's considerations of these violations.
Mr. Kemp, anything
Nothing
else?
further, Your Honor.
All right. And this is the suggested instruction, Mr. Kemp?
Yes, sir.
The one thing I would suggest the court add is the justice of the cause violation.
this is what I'm going to do. And I feel this is a very, very important to point this out from the very outset as far as the opening statement by Mr. Johnson. And I even think when we first approached, my first comment was, there's a lot of argument going on, and I think I showed a note on that, and that was very early on, and the record would reflect that. My point is this, when it comes to opening statements, they should be statements in anticipation as to what the evidence will be in the plaintiff and or defendant's case in chief. Nothing more, nothing less. Occasionally, lawyers do arguments, but it's up to lawyers to object to it, and each time we had an objection. Consequently, it wasn't waived. When I look here, and clearly, it's my recollection, Tim, if I'm wrong, but the great news was done even before the potential symptoms were showed on the screen. You can't do that, right? You just can't. Fantastic recovery. Well, we don't know what the recovery ultimately will be. And, but just as important, the way it was presented, that was argument. Brave in starting a business, that's argument. To the extent these damages exist, I think that's important because I've ruled as a matter of law, there's damages. And consequently, there's no question as to whether they exist or not. They exist. The determination would be the extent of the damages, not whether they exist. I don't want to, I don't mind saying this, I was thinking maybe I should grant a mistrial, and I don't want to go that far. I mean, I get it. I don't want to have to go through another 2 weeks, 3 weeks of jury selection, and I think this is often overlooked. From my perspective, I actually put in a lot of work trying to get the jury ready before the voir dire or jury selection process. That's what I do. I go down and meet them. I sit down and talk to them for about half an hour. I explain to them the Constitution. I put them under oath, and which I feel is very important. What I'm going to do is this. I'm not going to sanction. I'm not going to issue a $50,000 sanction, but I'm going to give the curative instruction on the last issue regarding justness of the cause. Take a look at that and see where that would be placed in the proposed instruction by Mr. Kemp.
Thank you.
Thank you, Your Honor.
And we'll finalize that.
Do we have the draft back?
Yes, you can.
If you want to look at that picture, it's accurate.
Oh, who typed this? Did you?
I typed it.
Oh.
Well, she's already.
We just put that?
No, what we could do is get that back to her and make copies of what you typed to me.
I can just print it,
Print it, yeah, print it.
yeah.
We're more efficient than I
If you
thought.
want to make sure that what I typed is
No,
accurate
no, you
to
can,
that.
no, go ahead, just type it out. Just go
We'll
ahead.
look at it.
No, print it, I'm sorry, print it. Tori, you amaze me sometimes. You can't hire her.
Don't think that hasn't crossed our mind.
And make sure we get copies for everybody, Tori. That was quick.
Thanks.
I thought they typed that, that was you.
I did. Defense counsel, please.
And I'll just step down for a few moments. When you're ready for me to look at the final proposal, I'll take a look at it.
All right. Thank you, ladies and gentlemen.
Okay, Mr. Johnson, have you had a chance to, for the record, to review
Yes,
the
Your Honor.
proposed curative instruction?
I've reviewed it.
Okay. And when I'm looking at it, it appears to me the primary change made as it relates to the prior submission would be, quote, "An attorney is prohibited from stating an opinion as to the justness of the cause." Is that correct?
That is correct, Your Honor.
Okay. Anything else?
No, Your Honor.
May I respond, Your Honor?
Yeah, you can.
So I object to the third sentence. What they added was, under our rules of professional conduct, an attorney is prohibited from stating an opinion as to the justness of the cause. I just want to make a record as to specifically what that justice of the cause was, what that argument was.
Your Honor, I can respond if you would like.
Yeah, you can.
Your Honor, he made the comments giving an opinion of the justness of their decision to open his company. He said they were brave to do this. That's his opinion of why they did that.
And our position is that is not a justness of the cause argument, Your Honor. They were brave to start it.
Your Honor, you have to.
If I could please finish.
Yeah, you can finish, and then we get a chance to reply.
Because then it addressed further down, also violated our rules. All right? That's loaded. Mr. Johnson also violated our rules suggesting real water officers were brave. Isn't that just what was misstated above as a justness of our cause?
That's an addition.
That,
I'm sorry,
It's-
Mr. Johnson, go right ahead.
thank you. Can I go ahead?
Yeah, go right ahead.
Thank you.
You're welcome.
Additionally, the last four sentences, Mr. Johnson also implied there were no damages by saying to the extent these damages exist. That's not accurate. That's not consistent with the record. I'm the one who said there are damages. Here are the special damages, and had them write it out above the pictures of the individuals, Your Honor. To state that I said there's no damages is completely inconsistent. The court already determined that plaintiffs were damaged by the drinking water. I said that in the opening statement. You are to disregard the argument that damages do not exist. I did not make that argument. I said the court has already ruled on it. It's fresh off the presses and quoted the order. So those four shouldn't be in there. I didn't make any opinions as to justness of the cause simply because I said my claims were brave to start their own business, Your Honor. I didn't say things like profits, over safety and things of that nature that were repeated repeatedly in plaintiff's opening statements. So for that reason, I think it should read the first sentence. While I disagree, but I respect the court's ruling, it's fine. First sentence. The second sentence is absolutely true. The third sentence, under our rules of conduct, an attorney is prohibited from stating an opinion as to justice of the cause. Based upon what they claim to be justice of the cause, Your Honor, I don't believe it applies. Further, it says, Mr. Johnson violated our rules by arguing plaintiffs were doing great and great news and made a fantastic recovery. If you believe that's a violation, Your Honor, I disagree respectfully, but I understand that was your ruling. And to disregard those arguments, that is consistent. Also violated our rules. Don't know why the term also is involved in that, why that is stated, because it's covered in the terms these. For instance, it reads, Mr. Johnson violated our rules by suggesting that real water officers were brave. This is opinion which is prohibited. You are instructed to disregard these arguments, not this argument. And that's where it should end. Thank you.
So, Your Honor, I mean, we've spent 45 minutes arguing this, and Mr. Johnson just basically repeated the same arguments he made before. The justice of the cause comes when he was talking about the individual causes before he led into all the things he said about, you know, where they are and their condition, and then got into their past medical specialists inaccurately with respect to Lisa King. But he, at that point, said you will have to judge the justness of the cause, and these are violations of the Nevada rules of professional conduct, Your Honor. They're clear violations. The curative instruction was approved. The only thing that was added from what was approved earlier was the justice of the cause clause. So the jury instruction should be given as written, Your Honor.
Your Honor, do you need any further explanation?
Mr. Park, I'm just looking at, under our rule of professional conduct, attorney is prohibited from stating an opinion as to the justness of the cause. And I just want some context for that a little bit.
And Your Honor, we discussed it earlier. I don't know if Mr. Johnson's feigning ignorance on this or simply wanted to just re-argue it. But the bravery was one comment. In addition to that, his arguments regarding their recovery, those were arguments. Those weren't evidence-based. That was another example. His comments in terms of damages, again, he can put up on the screen medical bills and then within the next paragraph indicate that if you find there's damages. Your Honor, I've tried too many cases on both sides of the V, and I've seen the tricks of the trade.
Oh, you have. You're one of the few, Mr. Park, I see that does both.
And I've tried defense cases in front of you.
You have.
$100 million cases.
Subrogation cases.
I've done it all. I hear Mr. Eglett over here, who I supremely admire, and Mr. Kemp, and I think I may have tried more cases in front of you than both of them. But I will tell you,
That's probably true. That's probably true.
being on both sides of the V, Your Honor, I have I've defense cases where they've had damages, and I've claimed there were no damages. They've had medical bills, and I've claimed, so what? That's practically what Mr. Johnson has done. He parades the numbers, and because you've tried two of these cases already, they parade the numbers and suggest this is the cap of their damages. And then he turns to these plaintiffs in front of this jury and says, if they have any. It's an affront, it's a slap in the face, and it's a way of him demeaning our clients and finding a way to tell these juries, even if they have some medical bills, that doesn't mean they were injured by real water, which is completely at odds with what the court has already instructed this jury to do. His jury nullification, Your Honor, is in violation of our rules. And we said that both in terms of 3.4E, but also in terms of Leoshi, which Mr. Eglett brought up while at the bench. I know Mr. Johnson knows better than this, and I appreciate the zeal in which he's attempting to defend his position, but it's insupportable. There's no way he can support his position.
All right. Thank you, Mr. Morrison.
You're welcome.
And this is the change I'm going to make, and I'm not going to make any change as far as the statement set forth in the curative instruction. I'm just wondering about the location of under our rules of professional conduct. And what I mean by that is this: if you read it, it talks about improper argument, and there's improper argument examples given. And then at the very end, I'm wondering if it makes more sense to put that as the last sentence.
That's fine, Your Honor.
Fine.
I will say me and Ms. Switzler went back and forth a little bit on where to put it.
And someone probably said it should be at the end. That's the way I see it.
And that's, we agree with the court, Your Honor.
That's fine.
Okay. You know what to do, Tori?
Justice of the cause of the sentence.
Yeah, under our rules of professional conduct. Yeah, last sentence.
All right, we have time for me to use the restroom real quick.
Yes, you can. Anyone that needs to take a break, you can take a break right now. We'll go off the record for a few moments.
Thank you.
All right, do the parties, wait. We're not ready yet. Have to address the
We're not
jury.
going to be ready for a minute.
Yeah. Anyway, ladies and gentlemen, did you enjoy lunch? And I apologize for the delay. I just want you to understand that, but we're making great progress as far as the case is concerned. And so, did we stipulate to the presence?
Yes, Your Honor.
Okay,
Yes, Your Honor.
Okay. And it's my understanding, we're going to, before we get started, we're going to have live testimony as part of the plaintiff's case in chief. Is that correct?
We're gonna do a video first, then we're gonna go.
That's
back.
okay, video. Video. And I just want to let you know what's happening. And before we get started, I'm going to issue to you curative instruction number 2 in this case. Ladies and gentlemen, the purpose of opening statements is to discuss the evidence that will be presented. This is not the time for a lawyer to argue. An argument is prohibited. Mr. Johnson violated our rules by arguing that the plaintiffs were doing great and had great news and made a fantastic recovery. You are instructed to disregard these arguments. Mr. Johnson also violated our rules by suggesting real water officers were brave. This is another opinion which is prohibited. You are instructed to disregard these arguments. Mr. Johnson also implied that there were no damages by saying to the extent damages exist. The court has already determined that plaintiffs were damaged from drinking real water. You are to disregard the argument that damages do not exist. Under our rules of professional conduct, an attorney is prohibited from stating an opinion as to the justness of the cause, period. All right. And so with that in mind, I think we're going to see a video right now. Is that correct, counsel?
Yes, Your Honor, we would call Dr. Michael Cosnet by video, and for the court, I think this is 32, about 32 minutes long, Your Honor.
Yeah. And ladies and gentlemen, for the purposes of this trial, you'll hear, and I think we talked about this, you'll hear some testimony from a witness by video, some by potentially over Zoom, and some live. You understand? Okay.
Good afternoon, Dr. Cosnet. Good afternoon. I don't anticipate your testimony will take long to go through that. Can you tell the jury a little bit about your education and current training? I'm a medical toxicologist. I'm a physician who specializes in the field of medicine, a subspecialty that deals with how chemicals and toxic substances affect health. I've been doing that for 32 years. I went to college at Yale University. I had a bachelor's of science in molecular biophysics, biochemistry. From there, I went to medical school at the University of California, San Francisco, graduated with my MD degree. Then I went on and I specialized in internal medicine. From there, I went on and got a second residency in occupational and environmental medicine, particularly focusing on how chemicals and environment affect health. And then I went on and did a third certification fellowship as a medical toxicologist at the University of California, San Francisco. And after all that, I was board certified in internal medicine, occupational medicine, and medical toxicology. And my wife said she would kill me. So we're going to be quick. What were you asked to do in this case? I was asked in this case to look at what could be the cause of, as a toxicologist, what could be the cause of what happened, when people sick from drinking real water. There were I was aware of the fact that the CDC and the FDA and Southern Nevada Health District had done some epidemiological investigations, and they came to the conclusion in the spring of 2021 that there was something in the water, and they, prevented the water from being sold. But CDC never came out, FDA never came out and said, well, what was the specific agent in the water? They didn't think it was infectious. So counsel came to me and they said, can you look at this and look at all the testing and everything that was done? And as a toxicologist, can you find anything that might have caused it? And so I proceeded to look at the evidence or the available information. And the first thing I did is I wanted to find out what medically has been examined, particularly of the type of liver disease that these people have. Because many of the people actually had to be considered for a liver transplant. And one of the studies I saw, and we want you to actually published in the American Journal of Gastroenterology, and it was a report on 4 of the people who underwent liver biopsy after being exposed to real water. You know, it's called acute liver failure due to manufactured alkaline water, a case series of real water-induced liver injury. And what we see, and what I read about this, is that there was a variety of different types of liver damage that occurred in these patients. They included inflammation, they included some cellular injuries, bile stoppage, which we call cholestasis, inflammation of the bile ducts, and even in some cases, scarring of the liver, which is a form of like cirrhosis, is a form of scarring of the liver. So I said, if something chemically in this water causes it, it has to be something that really causes liver damage. So the next thing I did is I looked at the FDA test reports. And they had a lot of testing, and I went through it all page by page. And one of the things that Dr. Stephan, I'm sorry to cut you off, for the record, the referenced article, Acute Liver Failure Due to Manufactured Alkaline Water, the case series of real water, that is Exhibit 8. And that's been pre-admitted already. No, I'm sorry, continue. What was the next thing I did? So the next thing I did is said, well, look at the testing that the FDA did, and do I see anything in there that raised an eyebrow to me that this could cause liver damage? And sure enough, buried in the listings of all the things, I saw reference to hydrazine being present. And it was present at a very high quantity. This is in the concentrate. It was used to make the water. And this is over a part per 1,000. Sometimes just by reference to toxic substances in water, we're concerned about parts per million. Okay? In arsenic, the standard is 10 parts per billion. And this is a chemical that's toxic, and it's present in the parts per 1,000 range in this concentrate. So it wasn't just this one sample. In fact, it turned out that they tested 3 different samples of the concentrate, and hydrazine was present in all 3. Okay? In close to the same amounts.
And Dr. Cosner, you're referring to the testing done by the FDA laboratories in Cincinnati. Is that right?
Yeah.
And the 2 testing reports that you're referring to are pre-admitted as Exhibits 6 and Exhibits 5.
So I knew that hydrazine, as a toxicologist, I knew that hydrazine was toxic. And I told counsel, I said, I think this is something that we really have to look into as the cause. And so what I decided is I was going to do a thorough investigation about what was known about the way hydrazine affects the liver, and also at what doses it affects the liver.
Dr. Cosner, in your review of the FDA testing, did you review any testing that the FDA did on the real water to concentrate that did not have hydrazine?
No. Every testing that you did on the concentrate showed hydrazine.
Thank you. So you referenced that you went about to investigate what is known about how hydrazine affects the liver. How did you investigate that?
Well, I reviewed a lot of information about hydrazine. In fact, let me show you a picture of the chemical structure of hydrazine. And this is a very simple molecule. It's 2 nitrogens and 4 hydrogens. It's inorganic. But this is a very reactive molecule. So when it gets into biological systems, it reacts with it, it can cause damage. Okay? So this, and then I said, okay, well, let's look at the literature that shows how does it damage the liver. And I looked for studies, and it's interesting. This has been known, it turns out, for a long time. This is one of the articles I found. This was published in 1908. It's called The Pathological Anatomy of Hydrazine Poisoning. And it turns out, in 1908, they gave animals a single dose, and a bunch of different types of animals, a single dose of hydrazine, and all the animals had liver damage. And they said, that's pretty remarkable. Now, that was a single high dose. So I wanted to say, well, what about situations where people or animals got lower doses, but over a longer period of time?
So, Dr. Cosner, as we're going through these scientific articles that you researched and looked at, before we get there, can you just tell the jury what is hydrazine? Hydrazine, like I said, is an inorganic chemical, and it's soluble in water. It dissolves very well in water. It has, and when it's just look at hydrazine, there's a little bit of an oily consistency to it. But when it's dissolved in water, it's clear and it just dissolves very well in water, and water by looking at it looks like clear water. What is it used for? You know, it's used for predominantly as a rocket fuel. It can be explosive and produce a lot of force when it's, and that's why they use it in rockets. They also use it as auxiliary power or emergency power in F-16s for in case the regular power will fall, that would be a backup power. So it turns out that many of the studies on the toxicity of hydrazine were actually done at the request of the U.S. military, at the request of the Department of Defense. And they did government reports on it. And it wasn't just in our country, it was also in other countries. And so I reviewed that data as well. And after you started looking into the scientific studies and data on the rocket fuel hydrazine, what else did you find? Well, the thing that I wanted you to be aware of is a lot of these studies, and I'm going to show you when I mention the studies, has to do with what we call dose. Okay? And dose is the amount of a chemical or drug that's taken or absorbed into the body. And we usually express it in terms of the amount the person takes in divided by their body weight. Okay? So for example, if you have 150 milligrams of a chemical like hydrazine, it could be any chemical, and we give it to someone, we want to know, well, how much does that person weigh? So that's often measured in kilograms of body weight. A kilogram is 2.2 pounds. So 100 kilograms, for an example, in the top line there, 150 milligrams of the chemical in a 100 kilogram adult, that dose is 1.5 milligrams per kilogram per day. Right? If you gave that same amount, 150 milligrams of the chemical, to a child who only weighed 10 kilograms or 22 pounds, who has a higher dose? Well, the child has 15 milligrams per kilogram. So we're going to talk, I want you to bear in mind that I'm going to mention the terms milligrams per kilogram per day. That's how you talk about dose in toxicology. All right, I'm going to ask you on this slide. So 100 kilograms, I'm used to the pounds. Pounds I understand. 100 kilograms is that about 220 pounds. So about an adult a little bit larger than, yes. What about 10 kilograms? 22 pounds. So the child. So that was maybe a treatment. When we talk about dose, if we're giving the same amount, the same quantity to an adult, they're getting a much smaller dose than the same amount given to a child. That's right. And is it fair to say that the greater the dose, the greater the harm in terms of a poisonous substance like hydrazine? Yes, that's true. Okay. What did you do then? So then I looked at studies that had looked at not just animals getting a single high dose, but getting lower doses over a period of time. And one of the studies that was published was done in Germany in 1988, and they actually, in this, they gave male and female rats different doses of hydrazine in drinking water. Okay, they gave it to them in the drinking water, and they gave it to them over the course of greater than a year. And then when the animals died, they did autopsies on the animals. And they had started this study because they thought they wanted to look at whether hydrazine caused cancer. It turned out it didn't cause cancer, but one of the things that they found was that it caused an increase in the prevalence of what's called bile duct hyperplasia, or a thickening or abnormality of the bile ducts. And those are an important component of the liver.
So this was an example of how chronic exposure to hydrazine at lower dose that didn't kill the animals right away caused them to develop abnormalities in the liver. And this appeared at a dose of 0.13 milligrams per kilogram per day in the males rats and 0.77 milligrams per day in the female rats. Why was it higher in the females than the males? It's not clear. That sometimes happens. There's gender difference. There were several other studies. I'm not going to go through every single one. This was one that was done and published in the Journal of the National Cancer Institute, where they gave hydrazine to hamsters, and they found at the lowest dose that they tested, this is not necessarily the lowest dose that caused this, but at 3.1 milligrams per kilogram per day, they had liver abnormalities by 19 weeks, and by 38 weeks, almost 2/3 of the animals had cirrhosis of the liver, which is a type of thing with fibrosis. It's very bad in the liver. Another study that was done in Japan more recently, and they gave hydrazine to the animals. And in this case, this was in rats and mice, and they found a dose of 1.8 milligrams per kilogram. There was an increase in liver enzymes. We've heard earlier about how liver enzymes can go up in people. In this case, well, they found this in the animals. In fact, they had very high enzyme levels at animals who were given 2.65 milligrams per kilogram. And there was another study that was published and discussed, I should say, it was reviewed in a scientific review of hydrazine, which is dozens and dozens of pages long, that was put together by the World Health Organization. And they found that there was damage to the brain and also damage to the liver at a dose as low as 0.03 milligrams per kilogram per day. And in this case, they didn't use just rats, they also used guinea pigs. Sometimes guinea pigs are more sensitive. There's variability, and it's not unusual in studies to see some animals are more sensitive than others, but there's variability. But these studies consistently showed that there was liver damage from long-term exposure to lower doses of the animals.
What about humans? Did you locate any reports of hydrazine exposure causing liver damage to humans?
You know, there were no experimental studies in people who specifically designed to detect liver damage. But there were three types of evidence that I want to show you. Some of them were workplace studies where people who worked with hydrazine and developed liver damage. One of them, there were some studies, there was actually a period of time where people were trying to use hydrazine to treat cancer. It didn't work, but it causes bad side effects on the liver. And then there's also, I want to tell you about the fact that there's a drug that was used to treat tuberculosis called isoniazid. And a side effect of isoniazid that's very well recognized is liver disease. In some cases, liver failure. How? The isoniazid is metabolized by hydrazine. Okay? So let's talk about these briefly. This is one of the studies that we saw. And this was published in Finland, and actually it was a gentleman who worked with hydrazine 1 day a week. You can't do it. They didn't specify exactly, but he probably had some inhalation exposure and dermal exposure. And he was a machinist. And after 6 months, he started to feel ill. And he went to see a doctor, and when he went to the doctor, he had jaundice. You know what jaundice is? Yellow jaundice. Your eyes are yellow. Sometimes your skin is yellow. It's what happens when you have when you have liver failure. And that's what he had. He had a very high bilirubin. That's what causes you to become jaundice. And he wound up actually dying. And they attributed his death to being exposed to hydrazine. And when they did an autopsy, they found evidence of liver damage. Now, I looked at how much we estimated he was exposed to, and I had to make some estimations. And I think his exposure could have been as low as 0.14 milligrams per kilogram. You see, I'm always highlighting the yellow because we're going to come back. Now, there were some other studies. Remember I told you about the studies that were done on people who were being exposed through cancer treatment. There was an unorthodox doctor, a doctor named Dr. Gold, back in the 70s. And he had this theory. He wasn't on a mainstream position, but he had this theory that got around, that hydrogen could somehow be helpful in treating cancer or helping people who were developing what we call cachexia, or loss of weight and thinning and wasting away, if they gave them hydrogen. So, because there was a lot of clamor in patients, especially patients who nothing else was working to do it, there were some studies that looked at it. They didn't do formal controlled studies, but they gave some people hydrogen, okay? And they published this. And this is one report in 1975. They gave some people with disseminated cancer, in other words, bad advanced cancer. They gave 29 of them hydrogen, and it didn't help them get better. But some of those patients got evidence of elevated bilirubin, liver damage, and some of them had elevated liver enzymes. Now, the National Academy of Sciences actually referred to this study when they were asked to look at the Gulf War veterans. Remember the Gulf War veterans? There's a lot of sense of this was back in the early in the Bush administration when they invaded Iraq, and there was concerns. And the veterans were maybe exposed to hydrogen because it was used in rockets, propelled rockets and missiles. So they looked at it and they said, in their opinion, looking at the data, that these individuals, some of whom had evidence of liver damage, were exposed to 0.2 to 0.7 milligrams per kilogram per day.
What about the drug isoniazid?
Well, just let me say real briefly, this is another study that I think is worth just mentioning real quickly. This was a gentleman who self-treated. He went to the internet and ordered hydrogen over the internet. And he took it to treat he had cancer of the maxillary sinus. Maxillary sinus is, sinus is in the head.
He was reading about Dr. Gold.
This was, even though most people said it didn't work, there's people who believe if they have cancer, they'll try it. And unfortunately, this man, he took it for 4 months, and then he went to medical attention, and he was jaundiced. And it was admitted to the hospital. He had severe liver damage. His bilirubin was 43.2. The normal was less than 1. And despite aggressive treatment, he went out to die. Okay, both hepatic and GI bleeding. And
Sorry, just cut you off. That's hepatic encephalopathy.
Yes, he died of hepatic encephalopathy, which is a form of brain swelling and brain damage that you get in the brain. Remember, that was talked about in some patients. In this case, had hepatic encephalopathy. So this is a guy who's taking hydrogen, and he died, and he had hepatic encephalopathy. And the dose, which we calculated, was 0.38.
Okay, now isoniazid.
All right. So isoniazid, as I mentioned, is a drug that's used to treat tuberculosis. Or if you've been exposed to tuberculosis, you have to take it for sometimes 6 months to 9 months. But it's well known that about 20% of the people who take isoniazid develop evidence of liver injury. And in some studies, as many as 1%, it becomes so severe that it can sometimes fatal. That's a side effect of isoniazid. And they looked in studies in animals, this is some of the studies we looked at, and they thought that it was the hydrogen that was responsible. And I can show you why they thought hydrogen was responsible. I'll talk loud, so hopefully that's okay. This is INH. This is the drug INH. And what I want you to notice, remember we said that hydrogen was 2 nitrogens and 2 hydrogens? This little piece here, when it's metabolized, it becomes hydrogen. Okay? And so they found out in their animal studies, it takes this enzyme to produce it. If this enzyme is inhibited, if you give them another drug, guess what? You don't get the animals didn't get the damage from the isoniazid. Also, you see this arrow here and this arrow here? This is an enzyme that converts either the INH or the hydrogen to other compounds, which are less powerful. This enzyme is called NAT2 or N-acetyl-transferase 2. This is the important point. People have different levels of that naturally. Okay? Some people have lower levels and some people have higher levels. The people who have low levels, it doesn't act as much. This process is slow. This detoxification process is slow. And they're called slow acetylators. And guess what? If you are a slow acetylator, you're more susceptible if you get if you get isoniazid to developing it. And probably, if you're a slow acetylator and you get exposed to hydrazine, you are going to be more likely to get liver damage. So that's why not everyone who took real water got liver. But there's a reason for why some people may be more susceptible. Okay, it's how much genetically this enzyme was formed, and we know there's different levels. And in some cases, as many as in some groups of people, ethnic groups, it can be as much as 50% of people are slow accepting.
Dr. Kazan, can we look at the dose that you found by isoniazid and then go to the chart?
Yes. So I actually said, okay, well, if you're taking isoniazid at the standard dose, how much hydrazine is produced? And my estimate, if you assume that 1 molecule of isoniazid gets converted to 1 molecule of hydrazine, and the standard dose of isoniazid, which is also abbreviated INH, is 5 milligrams per kilogram, then the dose of hydrazine that's causing this toxicity in some of the people who take INH is about 1 milligram per kilogram. So I presented to you a bunch of different studies with a bunch of different doses. So now you're wondering, well, how much hydrazine did the people get who drank real water? Okay. And I looked into that and did some calculations. And basically, if I can approach,
Well, Dr. Kazan, you looked at this, and based on the information that we know about the hydrazine that was tested in the concentrate, and how that's the process that's used followed to make the water, instead of it down a little bit in the finished product. And you came up with an approximate range given that information.
Yes.
And then compare that to the studies and the dosage, right?
So I looked at the median dose, and I also did some calculations here for the median dose and the 95th percentile. And this is what we got. The 95th percentile hydrazine dose for real water would have been 0.97, and this is for like people who are consuming. Now, some people could take a lot more, and some people have individual variability. But looking at the average dose, the median dose is 0.37, the 95th percentile dose. You see the numbers 0.97 and 0.37? They fit right in the range of the studies we just described from animals and from humans of the doses that were experimentally shown to cause liver damage. So I conclude, and it was my belief, to a reasonable degree of medical probability, that hydrazine in the real water was responsible for some people getting liver damage by drinking the
Dr. Kazan, just to sum up, the greater the dose, the greater the harm.
Yes.
Right? Hydrazine is in real water based on the information you looked at.
Right.
Hydrazine is rocket fuel.
If it's used in rocket fuel.
Hydrazine, the rocket fuel causes liver damage in some people who get a big benefit.
That's correct.
Thank you, Dr. Kazan. That's all I have for you, I think.
Did you see the setup as to how real water is made with big mixing tanks?
Yes.
I want to follow up on something you said. You said that hydrazine dissolves very easily in water. Is that
Yes.
What do you mean by that?
It means that, well, I don't have an exact amount, but it's not like putting vegetable oil in water where they separate out. If you put hydrazine in water, it goes into solution.
Okay, can we use like something that everyday people understand, like a house? Is it like when you're making spaghetti and they take a little bit of salt in the water and put a little salt and it's just gone after you started around with the noodles.
It's probably not as soluble as salt,
Okay.
but it dissolves in it. It dissolves.
Okay, I appreciate that. So the hydrazine that ended up in the real water is going to be pretty well dissolved.
Yeah. It's called miscible. It's suspended, very fine suspension.
So if I'm understanding correctly, basically the hydrazine that's going to be in the real water, you can't see it.
That's right.
You smell it.
Depends on how much was there. It's possible, sometimes it has an ammonia type smell if it's present in high enough concentration.
Is it going to be oily? Is the water going to be oily or it's all dissolved?
Again, it depends on how much.
Is it going to be red? Is it going to be a fishy smell?
Not always. I mean, like I said, it could be if it was high enough amount, but in general, not always.
Does it look like dirt in the water?
Dr. Kostek, all of the cases that you testified to today, were they all stated to a reasonable degree of medical probability? They were. Thank you.
Do we agree that that hydrazine at some concentration can be non-toxic?
Yes, I think that's a general paradigm in toxicology, particularly with respect to non-cancer outcomes.
And more specifically, you don't hold any, you haven't developed or disclosed any opinions here about the carcinogenic effects or potential carcinogenic effects of hydrazine.
That's correct.
And even more specifically, if we look at the general principle of hydrazine being harmless at some concentration or non-toxic, would we agree that there's some concentration at which it's not hepatotoxic?
Well, concentration is not a dose. I mean, concentration is a component of dose. So I think the question is phrased is incorrect.
Is there some dose at which hydrazine is not hepatotoxic?
Yes, I believe that there are doses of hydrazine that could be consumed that would not produce adverse effects.
All right. You don't hold any independent opinions about the chemistry of degradation of hydrazine?
I believe it can occur, but I'm not going to comment. My opinions are not going to talk quantitatively about the degradation, other than the fact that I recognize and I refer to it in my report.
Okay.
I mentioned that on the third paragraph of my report on page 11.
Yes. We agree, don't we, Dr. Kosnet, that we don't know the extent of the degradation in either the finished product testing results that Eurofins reported or in the E2 concentration results that the FDA reported?
I'm not going to comment or put parameters on the extent of degradation. That's beyond the scope of what I was asked to do.
You did not conduct any daily dose calculations to determine what the dose of somebody consuming the actual finished product test result concentrations would be.
Well, I didn't conduct I didn't provide an illustration of what it would be in my report, but just as you've gone through the math, it's linear. You can just divide it.
But nowhere in your report is there an opinion that it can be concluded that the intermediate duration, weeks to months, of ingestion of real water containing hydrazine at a concentration of 0.3 milligrams per liter, or possibly somewhat higher or lower, would be capable of inducing, let's start with acute liver failure.
Well, not explicitly, no.
Your Honor, that concludes Dr. Kosnet.
All right, thank you, sir.
And we call our next witness, which
Yes, Your Honor. Vanya Diaz is next witness.
Okay. And while you're getting the witness and setting him, I just want to refill my cup with some water.
Yes, Your Honor.
Okay, I'll be right back. Got it set up?
Chains on top of the wall.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
May I have you state and spell your name for the record?
Vanya Diaz, Vanya Diaz.
Good afternoon, Vanya.
Good afternoon.
Good afternoon, ladies and gentlemen. All right, first question. Are you nervous?
Do I look nervous? I am nervous.
It's natural, okay? Can you please tell the jury where you grew up?
So my name is Vanya. I grew up in Bulgaria. And I came here in 2001. I came as an exchange student. And I liked it a lot. So the circumstances allowed me to go to UNLV. So I finished my accounting degree in UNLV.
Are you currently married?
I am married. My husband's name is Roberto, and we have 2 kids, 2 boys. Christian, he's 15, to be 16 in about a month and a half. And then Matteo, my younger child, he will be 12 on Friday of this week. So I'm looking forward to a nice end of the week party.
Tell us a little bit about Matteo and Christian. What do they like to do?
Well, for anyone that has boys, they like to play a lot of video games. So I'm always on their case about not spending the entire time on video games, but they also are busy with their school, and both of them are in club soccer. So practice 5 days a week, 2 different fields, games on the weekend. As a matter of fact, a big tournament this weekend for both of the kids. So we stay busy running around all the time.
Who lives in your household with you?
So, well, currently there's so my husband, my 2 children, and then my father stays with us for about 8 months of the year. But I'm lucky to have my mom now visiting as well from Bulgaria. She'll be here for 6 months, and then she goes back for the summertime. So at the moment, there's 6 of us.
You mentioned that you came here and went to UNLV.
Yes, I did.
What did you get your degree in?
So my degree was in accounting, but during the time that I was going to school, I was working at New York. I was a cocktail waitress. And at my final year at UNLV, I was able to get into an accounting internship. And I had a great experience, but that experience helped me discover that accounting is not for me. So I never really did accounting after that. I stayed at my job. And then later on, I did some substitute teaching, and then I went into sales. So I currently work for US Foods, and I've been doing that for a while. I sell food to restaurants.
Tell the jury a little about your personal life. What kind of things do you like to do in your spare time?
Like to do? That's a big question. What I like to do is, I like to travel. I don't really travel a lot because I just don't have the time. I like to take gym classes when I can get to the gym. The intention is 3 days a week. Do I make it all the time? No. I'm currently learning meditation so I can stay calm. And I like to spend time with my family. We like cooking, so that's one thing that we do as a family. What I do in actuality is work a lot and stay on the soccer field for the most part.
Let's transition to why we're here. When did you start drinking real water?
I started drinking real water probably sometimes in the late 2019, but during that time we moved to a different house. So I know that the beginning of 2020 is when we had the home delivery in our new home.
And what attracted you to real water?
Well, like I said, I like food. I always like to research on different healthy things. My husband knew about real water. At that time, we thought that we always bought Arrowhead water, but there's a lot of plastic in the bottle, so we wanted to get a home delivery, and we were sold on the idea that alkaline water is good. Real water was a healthier water, so we decided to just get that.
Did everyone in your house drink real water?
The kids not so much because even to this day we still have a water dispenser, but they hate the idea of getting a glass, and so they prefer to drink bottled water. They did consume some real water, I would assume, at some point. My dad didn't really drink too much of that. He's old school, I would say, so. He drinks water from the filtered refrigerator. And then my husband drank real water, but I drank more than him.
Let's go back in time to the fall of 2020. Did you start to feel very sick after drinking real water?
I did. And I got really sick in November 2020. I probably had some signs that I was getting sick a little bit prior to that. However, as a busy working mom, unless my head is falling off, I try to ignore everything. So I just kept going. I've had upset stomach, just a general feeling of unwell, tiredness, but you think about it and I just tell myself, who doesn't? So just keep going.
Did there come a time where your symptoms progressed where you could no longer ignore them?
It absolutely did. So on November 12th, sorry. At that time I was working from home and I do a lot of computer work and I talk to people on the phone. So I remember trying to, stay focused and do my job. And I was on my computer trying to type and my hand was just doing that. I just couldn't type. I couldn't even hold my computer. And my brain, it was the weirdest feeling, but my brain was fried. My brain was absolutely non-existent at that time. And I remember talking to some of my customers. I do take orders over the phone. And they would tell me whatever they needed. And I just couldn't remember. Not even 2 minutes after, I couldn't remember. So needless to say, on that day, I messed up a lot at work. And my husband was at work on that day, but my father saw that I wasn't doing well, so I said, okay, let's go to the emergency. It was COVID, but what can you do if you don't feel well? So I went to the emergency.
Vanya, I have an exhibit with several of your medical records that I'm going to ask you to take a look at. Your Honor, may I approach?
Yes, you may.
It's marked as proposed exhibit 293. It's Bates numbers 2931 through 39. Can you tell me what those documents are?
Those are various pages of my medical records from the time that I was sick.
Your Honor, we would move to admit exhibit 293.
No objection, Your Honor.
Shall be admitted.
Your Honor, while we're on this point, I also have two other exhibits, exhibit 283 and 286, that I believe were previously admitted, just not on the record.
Do you have copies of those? Is that provided?
I don't have copies with me.
Oh, okay.
They're just two pictures.
That's 283.
Oh, yeah.
And then 286.
No objection.
Shall be admitted.
Thank you, Your Honor. Shane, can you please pull up exhibit 293, page 1? Vanya, if it's easier as well, I think the exhibit should be on that screen right there. This is a note from your trip to the emergency room on November 12th, 2020. It says you arrived in a private vehicle and were taken in by wheelchair.
Yes.
Were you having difficulty walking when you presented at the emergency room?
Well, I was weak. Most likely the difficulty came from, I had like a double vision, and like I said, my body was just jumping. So when you have double vision, it's really hard not to get dizzy. So the fear of falling is there, and I just felt very weak.
It also says you had nausea and vomiting for the last 2 days. Did you have those symptoms?
I did.
What happened at the ER on this occasion?
So on this occasion, I know that they did a lot of tests. I didn't ask too many questions. I didn't suspect. Who knew at this time? We didn't know much about COVID, so I didn't suspect much. They did a lot of tests on me. They asked me, what do I do? They suggested that I just go home and try to rest. Don't stress out. Don't overwork yourself. And then they said that if I don't feel good, I should come back, but I should try to just go home, take it easy, and take care of myself.
After your discharge, did you continue to drink real water?
Well, after my discharge, I went home, and yes, I did continue to drink real water because when you feel sick, the last thing you want to do is you want to be dehydrated. You don't have appetite, so what you do is you try to drink more water to stay hydrated. And usually my thought process is, if I have something inside of me that's causing me to feel unwell, I just want to flush it out. So most likely that's what I did on that day too.
And did your condition worsen?
My condition did worsen because I went home. That was a Thursday, because the next day, I remember November 13th is a Friday. So I
Friday the 13th?
Friday the 13th. I can't forget that. So yes, my condition did worsen because I actually just saw the time here. I was trying to recall. But after going home, I just couldn't stay awake. I wasn't asleep, but I don't know how to explain it. I was lifeless, basically laying down with my eyes closed. you hear everything that's going around you. My kids are there. Obviously, they're asking me, how am I doing? What were my responses? I have no idea because I was there. My body was there. My mind was somewhat there, but I was in La La Land.
Did you feel nauseous? Or?
Very nauseous. And then I had the abdominal pain, like I said.
So what happened next?
What happened next is my family advised me just go to bed, take a good night's sleep, and then you wake up and be brand new. So I hoped for the same thing, and I don't remember how I went to sleep. But on the next day, like I said, it was Friday. So usually I wake up at 6 o'clock. I have an alarm set for 6 o'clock each day to this day. And it's pretty loud. But on the next day, I did not hear my alarm. So my husband sleeps right next to me. He wakes me up. Let's go to work. I try to get up. And at that time, I used to wear this Fitbit like watch because I was trying to stay active and do my steps and stuff. And I get up from bed and I'm so dizzy. And I feel like my chest is about to explode. So I look at my watch and I see a heart rate of 165 just standing, trying to take a few steps to go to the restroom. So my husband sees that too. He drags me to the bathroom. I don't know how I get dressed. I can't really think of that.
Were you able to walk to the bathroom?
With his help. So, and then he says, let's go to the emergency. We are going. And I said, and I know that I was opposing to that because I was just there yesterday. So why would I go and waste another half day there to go over the same symptoms? But he insisted, and we went on the way to the emergency, for which I'm grateful to this day, because if I stayed home, I don't know where I would be today.
What happened when you got to the emergency room?
So we go to the emergency room. He's allowed to come with me to the waiting area. Basically, we check in. I try to keep a straight face, go through the symptoms as much as I can. He helps me. And then all of a sudden, that's quite humiliating, but I'm telling you, because it happened, I just peed myself and then fainted. Just lost consciousness. So that's what happened.
What's the next thing you remember?
The next thing I remember is a bunch of doctors. They didn't let my husband with me, so a bunch of doctors running, and I know that they did a lot of tests. Like I explained earlier, I wasn't unconscious the entire time, but my brain was just on and off. So I remember doctors asking me a bunch of different questions. I know some of the questions were, what year is it? Who is the current president? And unfortunately, I did not answer any of those questions right. I still had my work computer with me because that's what moms do. And I just remember floating, basically. That's what I remember. I remember floating, which was kind of a good experience because I remember a lot of flashes of pictures of my family and some people that are not with us. And just, I don't know if I should call that hallucinating or out-of-body experience, but that's what I remember. Yeah.
What was your husband's reaction when you peed yourself and fainted?
About that, I can only talk after the fact. My husband, he has a poker face. He never expresses any emotions or fears, just like most men, I would say. But he admitted that he was petrified. He was scared. He said he was scared to go home because we have 2 young kids and we have no idea what's going on. So to see me in that condition, he knew that there's got to be something.
And what about you? Were you petrified?
Yes and no. I wasn't really, I was and I wasn't during that time in particular because I just wasn't myself. I didn't have the strength to understand what's going on. I had the fear, of course, but I was in the hospital, so I was just hoping that whatever it is, I'm in the right place, and I was hoping that I'd be in good hands.
Shane, can we pull up Exhibit 293-6, please?